Okay, guys, welcome to Making a Murder, my journal. And today we're going to do the supplemental to the post. Oops, wait. Okay, let's see if that's a little better so we don't get the back feed. That's terrible. Look at my screen, it's going crazy. Okay, if you guys can hear me, can you go ahead and let's do a sound check? Somebody in chat, can you hear my voice? We'll wait and see who responds. We'll type a little bit. Sound check. Janice can hear us. Okay, let's go ahead. Yes. Wonderful. Thank you guys. Hi, Boston. Hi, William, Jennifer, Bumble, Janice, John, Alex, G, Michelle. All right, let's get rolling, guys. I thank you so much for joining me. I have not read this, so bear with me if I stumble over big words. I'm just normal housewife here, wanting to share this with you. So what we're going to do is we're going to go to the Stephen Avery library, which we'll click this and get us a new tile. So what we need to do is, let me make sure everything's good on that. You're going to type rubber ducky Stephen, do not space, Avery files.com. Give that a little click. We'll go ahead and give it a minute to upload. And here we are. We're at the welcome to the Rubber Ducky Stephen Avery Files, newly released 3/12/19, Supplemental 974.06, Post Conviction Relief. And we'll come back over here and I'll check with chat. Welcome everybody. Hi Scotch. Hi Erica. Did everybody see what I was showing them on the screen, the newly released in the library? Yep. .com. So you're going to go, it's actually, let me type it for you one time. I would like everybody to grab the form if you want to read along with us. And it is Stephen Avery Files.com. And that way you can read right along with us as we go through this. Hi. Jennifer Doesright was trying to read the motion at work, not happened. Thank God it followed up on the motion. Thank you. Yes. We're going to get to this. All right. So let's go ahead and I've entered it. We're going to give this a little click and see where it takes us. And it takes us, if you already have your library card, which is your Microsoft Office password to get into OneDrive, then your library card will work for you on this, and it's going to a document for us. And here it is. Oh, everybody excited? We'll let that download just a minute. Very, very exciting. Thank you too, Foxes. It's all about everybody coming together, no matter what YouTube channel you have, no matter if you're on the side where you're talking or you decide where you're supporting, we're all together on this. So it's brilliant. And we have a great leader in Zellner. So it's our pleasure. All right. Let's go ahead and give this a little enlargement so we can actually read it. Whoa. Goodness sakes alive. All right. We're almost to a comfortable, about right there, I would think. So this is dated 3/11/2019. If you notice, it's 3/12. And there was a little frowny face at Zellner's site for quite a while, so it must have been not shared till today. This is Supplemental 974.06 motion for post-conviction relief pursuant to the state's violation of Wisconsin Statute 968.20. Okay, I will be right back. I'm just gonna get the dog in the kennel a little bit, give her a little water, and I'll be right back. Sorry about that, guys. Apparently, I either have a snoring dog or a whining dog through every video. Okay, this is Kathleen Zellner, Stephen G. Richards, and we're filing our supplemental. So you have quite a few cases that she references here from the Brady versus Maryland on. Um, and these, you can see right here, Halbach versus Avery Manitowoc case on 34. And we're going to go ahead and get to the guts of this. This is a very important one here. Youngblood versus Arizona. You're going to hear that reference quite a numerous times. All right. It looks to me that we're getting to the guts of this on page 5. And is on a remand from the Wisconsin Court of Appeals, 2nd District, case number 172288. And we, the petitioner of this, state that this is a supplemental 974.06 motion for post-conviction relief pursuant to state's violation of Wisconsin Statute 968.205 and Youngblood versus Arizona. There it is, guys. Okay, now comes defendant Stephen A. Avery, Mr. Avery, by and through his current post-conviction attorneys, Kathleen Zellner and Stephen Richards, and hereby respectively moves to this court, pursuant to Wisconsin Statute 974.06 and Wisconsin's Court of Appeals order of February 25th, 2019, for an order reversing, you guys, the judgment of his convictions and sentence and ordering a new trial. Woohoo, everybody give a moment to do their little happy dance. Whew. Okay. In support of this supplemental motion, Mr. Avery states as follows. Introduction. In 2007, the state spent an enormous amount of time and effort perpetrating a fraud upon Mr. Avery's jury. In order to win Mr. Avery's conviction and elude everyone else as a perpetrator, the state had to convince the jury that Mr. Avery alone was connected to the crime scene. To establish a crime scene linked only to Mr. Avery, the state created a narrative that Teresa Halbach, Miss Halbach, was murdered in Mr. Avery's garage and burned in his burn pit. It was essential to the success of the state's narrative that all Miss Halbach's remains were located within yards of Mr. Avery's residence. If the crime scene was a quarter mile away in the Manitowoc gravel pit, then the state's theory would have been refuted that Mrs. Halbach never left the Avery property alive on October 31st, 2005. If Mrs. Halbach's remains were actually in the gravel pit, then the defense would have been able to substantiate and not just speculate about an alternative theory that someone else murdered Miss Halbach and moved her bones to Mr. Avery's burn pit to frame him. In order to successfully convict Mr. Avery, the state presented a false forensic story to the jury, which claimed that the bones in the gravel pit were not evidence because they were not human. Therefore, they could not have been Miss Halbach's. The state's misrepresentations to the jury were not uncovered until 2019. The state, by its actions in returning Manitowoc gravel pit bones to the Halbach family in 2011, has implicitly admitted that the bones were not only human, but they belonged to Miss Halbach. This stunning action and admission undermines the state's entire theory at trial that was used to convict Mr. Avery and undermines confidence in the integrity of his verdict. The issue on remand is, did the state violate Youngblood versus Arizona when it returned the human bones to the Halbach family in 2011 without giving notice to Mr. Avery or his counsel, in violation of Wisconsin Statute 968.205 and the April 4th, 2007 trial court order? The answer is indisputably yes. The state took the unilateral action of commingling the human bones from 3 locations, thereby destroying any possibility that the gravel pit bones could be identified as human and subjected to more sensitive DNA testing to determine their identity. The omissions of the state that Mrs. Halbach's bones were in the gravel pit changed the scene of the crime to the location which is contrary to all representations made to the jury by prosecutor Ken Kratz, Prosecutor Kratz, to obtain Mr. Avery's conviction. In 2007, the state misrepresented to the jury known facts and concealed evidence. In 2011, the state acted in bad faith when it violated Wisconsin and federal law by returning human bones to the Halbach family. In 2018, the state continued its pattern of concealment with the appellate court until it was caught. Mr. Avery is entitled to have his conviction reversed and granted a new trial. Okay, I'm going to grab a drink and we're going to continue on to procedural background. If you have any questions up to this point, please do post them. We're going to continue. This is a very lengthy process, so bear with me. You can pause this. You can stop this. This will be posted for later if you cannot stay for the whole live. And I do apologize that this is going to be a long thing. So I'm going to grab a drink. I'll let you guys say hello. I see you all. Thank you, Linda G. and Shadrach. And I will be back. All right, guys, if you had a couple minutes there to catch your breath, I grabbed a drink. I think we're doing good. We're going to go into procedural background. Procedural background. On December 17, 2018, Mr. Avery filed a motion to stay appeal and remand the cause for new scientific testing. Said motion is attached and incorporated herein as Exhibit 1. Mr. Avery requested to perform newly available DNA testing on the gravel pit bones. The motion was denied by the appellate court on December 28, 2018, as premature. On January 24, 2019, Mr. Avery filed a motion to stay appeal and remand the cause for proceedings on claims for relief in connection with the state's violation of Wisconsin Statute 968.205 and Youngblood v. Arizona. On January 29, 2019, the state filed a response in opposition to Avery's third petition to stay the appeal and remand the case to the circuit court. The state's response is attached, incorporated herein as Exhibit 4. On February 1st, 2019, current post-conviction counsel filed defendant appellate's reply to the state's response in opposition to Avery's motion to stay the appeal and remand the cause to the circuit court. On February 11th, 2019, current post-conviction counsel filed a letter with the appellate court attaching additional undisclosed documents. Let's go ahead and we'll scroll up because that's my favorite pastime is scrolling. And she goes on to name quite a few other times that they have tried to get through this. On February 25th, 2019, the appellate court granted Mr. Avery's motion to remand to permit him to pursue a supplemental post-conviction motion raising claims for relief in connection with the state's violation of Wisconsin Section 968.205 and Youngblood v. Arizona. The appellate court specifically made the following findings. Number 1, the state's objection does not address the merits of Avery's claimed statutory and constitutional violations, and it has not responded to Avery's supplemental filings alleging the possible destruction of evidentiary items which it appears the parties previously agreed to preserve. Let's stop right there. So, on that little section, you guys, they are stating, the appellate court is stating that the state has not addressed the problems, that it's just been left open, and that also has not responded even to the allegations that the state has destructed evidence. So we'll continue. Number 2, having considered the parties' submissions, we will determine the best course of action is to grant Avery's motion to stay the appeal and to remand under Wisconsin Statute 808.075 subsection 5. Though we are not required to remand, we determine that this procedure strikes an appropriate balance given the specific circumstances of this case. Due to this case's extensive history, there is a benefit to having existing claims developed or litigated while they are relatively fresh, rather than postponing, I'm sorry, I'm going to try to say this word, rather than positioning the claims to be procedurally barred in a future proceeding. Let's stop there. So the second thing they're saying is better now than later, because later it could get too long in the story and get dismissed or barred from being even claimed. So they're agreeing that Ms. Zellner has the right to bring everything to the table at once, whereas the state is saying, let's focus on one little thing. Zellner, you're bringing too many different things together here, two different topics. And she's saying they're all the same topic. I'm just putting the bullet points together. And in this, the appellate court's agreeing. Number three, we desire a ruling on the merits so that all claims to date can be considered in a single appeal. The briefing in this appeal has not commenced. There appears to be some potential overlap between the old and the new issues. So the state is saying that this seems to be an ongoing issue in that statement. All right, I'm going to grab a drink and we're going to start on factual overview. All right, and to continue, we're back now with factual overview. The state's case. The state's conviction of Mr. Avery was based almost exclusively on forensic evidence. At trial, the state told the jury that all of the incriminating forensic evidence was in close proximity to Mr. Avery's residence. Prosecutor Kratz, in his opening statement, relied upon several computer generated scene models which allegedly illustrated the location of incriminating forensic evidence and its link to Mr. Avery. Prosecutor Kratz claimed that Mrs. Halbach was murdered and mutilated in Mr. Avery's garage and burn pit. Now quoting Prosecutor Kratz's opening statement. Prosecutor Kratz claimed that the proximity of Mr. Avery's burn pit to his residence was particularly incriminating to him. In his opening statement, Prosecutor Kratz told the jury, this particular computer generated animation is important to embrace or to for a jury to look at in the case because the burn area is clearly visible. How close it is to Mr. Avery's garage, how close it is to the trailer, how close it is to the other area. What's called the curtilage, that is the area that surrounds Mr. Avery's property, all becomes important. Dr. Eisenberg will identify all of these bones. She will identify from a female skeleton and from examples that are used all the different parts of Teresa that were found. And as I mentioned, at last, or at least briefly, before other analysis of bones and tissue, other things to point to, if in fact the state even questions whose bones and whose tissues is behind Mr. Avery's property. The state's expert regarding the bones. The state's examination of its forensic anthropologist, Dr. Eisenberg, about the gravel pit bones focused exclusively on the non human bones and three, quote, possible, unquote, human bones associated with tag 8675. Despite the fact that the Calumet County ledger sheets referred to multiple human bones in three additional piles in the gravel pit. Prosecutor Thomas Fallon Prosecutor Fallon never once questioned Dr. Eisenberg about her worksheet, which described those human bones in the gravel pit. Dr. Eisenberg's bone evidence report is attached, incorporated herein as Group Exhibit 10. Dr. Eisenberg was asked the following questions by Prosecutor Fallon about the suspected human pelvic bone in the gravel pit. Question. In the terms that suspected bone fragment, can you say to a reasonable degree of scientific certainty that that was human bone? Answer. Um, I cannot. Question. And why is that? Answer. Um, I did not. There is a potential for using microscopic to look, for example, to try and confirm if suspected human bone might actually be human bone or animal bone. But given the condition of the remains, I do not believe that cutting into the bone that would survive those kind of tests. So I didn't perform them. Prosecutor Fallon chose to emphasize the other non human bones associated with the pelvic bone while ignoring all of the other human bones in the gravel pit. On redirect examination, Dr. Eisenberg testified. Question. All right. Now, just so we're crystal clear on this, the various fragments from the gravel pit southwest of the property, originally you were only able to determine one was clearly non human. In your subsequent review and analysis, you determined several more were clearly not human. Is that correct? Answer. That's correct. Question. And as a matter of fact, there was only three left that you had reasonable suspicion on that could be human. Is that correct? Answer. That could possibly be human. That is correct. Answer. And as a matter of fact, or I'm sorry, question. And as a matter of fact, as you sit here today, you cannot tell us those bones to a reasonable degree of anthropology, or I can't even say that, anthropological, or scientific certainty are human. Can you? Answer. I cannot. Now we'll go to Prosecutor Kratz's closing argument. In his closing argument, Prosecutor Kratz emphasized the bones in Mr. Avery's burn pit. He, Mr. Sturdivant, found the bones, the small bone fragments, intertwined or mixed in with the steel belt from tires. All right, the bones being intertwined and mixed in is the state's or one of the state's strongest argument for this being the primary burn site. Prosecutor Kratz also focused on the elimination of other burn sites. Mr. Pivito, as you heard, however, also recalled that the bone fragments were intertwined with steel belts and, I believe, rendered similar opinions as to the primary burn site. Mr. Pivito also eliminates other burn locations. And again, Prosecutor Kratz emphasized the number of human bones in Mr. Avery's burn pit. What she also tells you is that every bone, at least a part of every major bone group, has been recovered from the burn area, from that which is behind Stephen Avery's garage. Prosecutor Kratz told the jury the events at these two locations, Mr. Avery's garage and burn pit, told the quote, the whole story, unquote, and the only person committed to this crime. Now, there is a footnote note here, and it's worthy, so we're going to read it. The footnote 2 is in the Dacia Pine, or opinion, the court references the state's theory that Brendan participated in raping and murdering Miss Halbach with Mr. Avery, which contradicts the state's theory in Mr. Avery's trial that he was the only perpetrator. In Brendan's trial, prosecutor Kratz claimed that Miss Halbach was killed by Mr. Avery stabbing her in the stomach, Brendan slitting her throat, and Mr. Avery manually strangling her. Prosecutor, and then we lose, where's the footnote? I'm unclear where that was going. We'll continue. In his closing argument, trial defense counsel Jerome Buting, Mr. Buting, stressed the importance of the bones found in the gravel pit when he said, if that body was burned somewhere and then moved and dumped on Mr. Avery's burn pit, then Stephen Avery is not guilty, plain and simple. Now, that is why the state has gone to such trouble avoiding the fact that the bones were moved. That's why you heard nothing about it here, because it does not fit with their theory that Avery is guilty. Other incriminating evidence linking the Manitowoc County gravel pit to the crime scene. In addition to the human bone fragments found in the gravel pit, there is an abundance of old and new evidence establishing that the crime scene was in the gravel pit and not at Mr. Avery's residence and garage. Mrs. Hawbuck's body was put in the Yasa Janda or Yonda burn barrel and transported to the gravel pit after sunset. The body was burned in the burn barrel, and the odor was detected by Travis Growley on County Highway Q. Wow, stop right there. I don't know about you guys, but this is a very new name to me. And so we will be doing a lot of follow up investigation to try to nail down where this all fits together. Now, Highway Q is running along there where Cuss Road would be a runoff road that dead ends, but it really doesn't dead end. Cuss Road just gets a small, narrow traveled path, rarely traveled path that leads to the quarry. So that's very, very important there. And let's continue. The scent and cadaver dogs reports corroborate that Miss Hawbuck and her vehicle were in the gravel pit. Specifically, the cadaver dogs hit on two burn piles in an area of the large concrete slabs in the gravel pit. Blood from an unknown male was found on the rock in the vicinity of the gravel pit bone piles and excluded Mr. Avery. And they are referencing Wisconsin State Crime Lab Exhibit CX. Yay! Happy dance, happy dance. Take a moment. Everybody stop right there. I want to give a shout out to TikTok Manitowoc and to Seven Pairs of Panties and to Eric Coes and to CA F and everybody that I could possibly imagine to Millbilly for sticking on this case because right there you see our work on this page. Right there, you guys. All the support from the fans coming together to make us stay on this case and provide information that links all of this together. And you see that right here. Happy dance. I got goosebumps. All right, we'll continue. Whew, take a breath. Wisconsin testimony has also linked the gravel pit to the crime scene. The edited flyover video shows no tire tracks on November 4th, 2005, leading to where the RAV4 was found. But tire tracks leading to the RAV4 were present on November 5th, 2005, strongly suggesting that the vehicle was driven from the gravel pit onto the Avery property and planted. Oh boy, we've all seen these flyovers, we've all seen these tracks, and then there were no tracks the day before. And we continue. The state's illegal transmittal of the bones to the Halbach family. I'm going to take 2 minutes, grab a drink, digest some of this, let you guys chat amongst yourself. I am going to peek into the chat. We're going to take just a reprieve here for a moment, and then we will come back to the state's transmittal of the bones to the Halbach family. Oh, exciting news, you guys. I'm so excited. Happy dance, happy dance. Okay, guys. I don't know about you guys, but I feel on cloud nine right now. I'm just so excited about this motion. And here we go. Take a deep breath and let's count to three and we're going to dig in. The state's illegal transmittal of the bones to the Halbach family. Mr. Avery's motion to stay in remand for scientific testing. And here we go, folks. On December 17, 2018, Mr. Avery filed a motion to stay and remand this appeal for scientific testing of several suspected human bones recovered from the gravel pit. Specifically, Mr. Avery proposed rapid DNA testing that has been successfully used to obtain DNA identifications from bones burned to a degree similar to those recovered from the gravel pit. This testing, argued Mr. Avery, is relevant and material because the identifications of the bones as Mrs. Halbach's is compelling evidence that her murder and mutilation did not occur in a location connected exclusively to Mr. Avery by the state. Thus, Mr. Avery argued if the rapid DNA testing identifies Mrs. Halbach's bones in the gravel pit, two inferences are reasonable. Number one, Mr. Avery is not the murderer. And number two, the bones recovered from Mr. Avery's burn pit were planted. On December 28th, 2018, the appellate court denied Mr. Avery's motion for DNA testing of the bones, finding that the scope of the pending appeal is limited to review of the circuit court's orders denying Mr. Avery's Wisconsin statute 974.06 motions, and that further scientific testing of the evidence was not necessary to determine the instant appeal. Yep. The discovery of the previously undisclosed September 20, 2011 police report and updated ledger sheet. So let's stop there so that you guys understand. We had there was a FOIA, Release of Information Act, that did obtain a numerous amount of documents, including a Casio log evidentiary log. Now, Zellner did have this log, and she had it all along. The complication was she didn't know there was pages missing because they didn't give her the completed log. And somebody came along and had the completed log. And so this is where we find that she now has new information that was being withheld from her. And that's why you see this major beef here. So, the discovery of the previously undisclosed September 20, 2011 police report and updated ledger sheets. After filing Mr. Avery's December 17, 2018 motion, current post conviction counsel received a copy of a previously undisclosed police report from a third party. Stop there. That third party, you guys, is an armchair sleuth. Okay? That's why you're important. Doesn't matter who their name is. It doesn't matter who claims credit. The point is, somebody did it. Somebody decided that they wanted to know if she had it. They had the confidence to follow through. And luck would have it that we provided someone provided informations. And congratulations for being such a part of the team, you guys. And now we continue. On January 24th, 2019, current post conviction counsel received her own copy of the September 20, 2011 report from the Calumet County Sheriff's Office. On February 8th, 2019, current post conviction counsel received updated ledger sheets that had never been previously disclosed to prior counsel. Those updated ledger sheets confirm the September 2000 disposition of the human bone fragments to the Halbach family. Parentheses, the previously undisclosed updated Calumet County ledger sheets are attached and incorporated herein as Exhibit 14. The September 20, 2011 report reflects that Deputy Jeremy Hawkins of the Calumet County Sheriff's Department, along with Sergeant Investigator Mark Wiegert of the Calumet County Sheriff's Department, Attorney Thomas Fallon, and Attorney Norm Gahn, removed from evidence. Oh, my dogs are barking. Sorry, guys. You'll have to deal with that. Um, I apologize on that. I always have dog issues in every video. In every video, they're either snoring or barking. Removed from evidence all property tags that contain human bones. So let's stop there. We have Thomas Fallon. This is the gentleman that helped establish the statute with the state of Wisconsin for the law that required us to retain biological evidence associated with anyone that was incarcerated on a crime that involved the biological evidence. He's the one that helped establish the law. So let's really look at this paragraph very closely. What it's telling you is that he now turned around and helped facilitate the destruction of the said evidence in question. So we're going to reread this paragraph now that you understand. He helped set that up, that we would retain those. He established that law with the state of Wisconsin. Now let's see what he does with the other side of his cheek. The September 20th, 2011 report reflects that Deputy Jeremy Hawkins of the Calumet County Sheriff's Department, along with Sergeant Investigator Mark Wiegert of the Calumet County Sheriff's Department, Attorney Thomas Fallon, and Attorney Norm Gahn, removed from evidence all property tag numbers that contained human bones. Wow. Attorney Norm Gahn and Prosecutor Fallon viewed the items under the property tags along with Dr. Eisenberg, reported, determined which bones could be returned to the Halbach family. Wow, wow, wow. Specifically, Dr. Eisenberg's report identifies by tag number human bone fragments from the gravel pit. Property tag numbers 7411, 7412, 7413, 7414, 7416, 7419, 7420, 7421, 7426, 7434, 8675. So I counted 11 just now. Dr. Eisenberg identified 7 tag numbers as having human bone fragments, 1 tag number as maybe human, and 3 tag numbers as being possible human. A chart based upon Dr. Eisenberg's report identifying the human bone fragments from the gravel pit that were returned to the Halbach family is attached and incorporated herein as Exhibit 15. A chart based upon Dr. Eisenberg's report identifying 11 tag numbers of human bone fragments from Mr. Avery's burn pit that were returned to the Halbach family is attached and incorporated herein as Exhibit 16. A chart based upon Dr. Eisenberg's report identifying the 2 tag numbers of human bone fragments from the Dassey Yanda burn barrel, barrel number 2, for all you barrel fans, that were returned to the Halbach family is attached and incorporated herein as Exhibit 17. At trial, Dr. Eisenberg testified as to the location of the 3 burn areas: Mr. Avery's burn pit, the Dasayanda burn barrel, and 1 location in the gravel pit. In 2016, Susan Hagopine of the Wisconsin State Public Defender's Office, who had been Mr. Avery's prior post conviction and appellate attorney, provided a current post conviction counsel office her entire file pertaining to WSPDO's representation of Mr. Avery. The September 2011 report is not present in current post conviction counsel's files kept on this case. On January 3rd, 2019, current post conviction counsel contacted Ms. Hagopine to request that she confirm whether she had ever seen the September 2011 report. Current post conviction counsel had obtained an affidavit from Ms. Hagopine. Hagopine's affidavit is attached, incorporated herein as Exhibit 19. In her affidavit, Ms. Hagopine explains that her representation of Mr. Avery began in July 2007 and ended when the Wisconsin Supreme Court denied his petition for review on December 14, 2011. On September 20, 2011, Ms. Hagopine and her counsel, Martha Askins, were Mr. Avery's attorneys of record. Ms. Hagopine has no recollection of having seen this police report before current post conviction counsel delivered it to her on January 3rd, 2019. Further, Ms. Hagopine does not recall having a conversation with a representative of the state pertaining to tendering items of evidence from Mr. Avery's criminal case to the family of Mrs. Halbach. Moreover, Ms. Hagopine avers that had she seen the report or had a conversation with a representative of the state regarding the return of the items of evidence to the family of Ms. Halbach, she believes she would recall it. Attorney Hagopines and Askins filed Mr. Avery's Wisconsin Statute 809.30, subsection 2, post conviction motion on June 29, 2009. That motion was denied by the Circuit Court on January 25th, 2010, and attorneys Hagelpain and Askins timely appealed on February 10th, 2010. This court affirmed that Circuit Court's order denying relief on August 24th, 2011. So let's stop there a minute. What they're basically saying is you can totally destroy biological evidence. Everybody has to be in agreement. So everybody has to say yes to this. You have to ask the defense. You have to ask the post conviction relief lawyers. You have to get the state on board. You have to get county on board. Everybody, the person that's being incarcerated has to agree to this. And then yes, that evidence can be gone, but it wasn't asked. And not only was it not asked of Miss Zellner, but it wasn't asked of two other lawyers that handled the post conviction. They did not even know about it, and they are saying they would remember if they had been asked, and there was nothing. So this is where we have the violation of the state statute. Okay, we continue. Then, as discussed previously on September 20, 2011, during the pendency of Mr. Avery's appeal, the Calumet County Sheriff's Department, together with Prosecutor Fallon and Attorney Gahn, arranged for the return of the human bone fragments from the gravel pit and the other human bone fragments from Mr. Avery's burn pit and the Dassey Yanda burn barrel to the family of Teresa Halbach. Mr. Avery has provided an affidavit that he, like his attorneys at the time, was never notified of the human bone fragments had been given to the Halbach family. Well, we are going to continue. On September 22nd, 2011, attorneys Hagopine and Askins filed their petition for review with the Wisconsin Supreme Court. That petition was denied on December 14th, 2011. So, what we're dealing with basically is the post conviction lawyers, attorneys, Hagopane and Askins, both were going through and filing motions, not realizing that this transfer of the biological evidence had been suppressed from their knowledge. So they were filing things trying to get to this evidence, trying to get a hold of all of it. It's being given away. And the petition is being denied to even talk about it in a hearing. So that's a big deal. They're not talking about it, they're hiding it. And Zellner's saying, it's all been caught up here with the armchair sleuth that sent this in and said, hey, look at this. You're missing a document. I'm going to take a moment. We're going to check on chat, grab a drink, and come back. We're going to start off with Wisconsin's Preservation of Biological Evidence Statute. Now, this gets a little, I do need a drink, you can hear. This gets a little bit technical here, but it is extremely important that we understand this law. I'm sure if you've watched this videos of Eric Cozy or mine or of, others, you've heard this law, but we still want to reiterate what it is because it is in our motion. So let's take a 2-minute break here and we will come back to Wisconsin's Preservation of Biological Evidence Statute. All right, I know that wasn't quite 2 minutes, but I feel like I got my whistle wet, so we're going to continue. There's so much to this. We're on 17 of 41. And so this we're only a third of the way there. I'm trying to keep it straight on task for everybody, but we need to understand this because as we go forward, if we do get a retrial, you'll need to understand what all this backlog material, how we got there and what she's talking about when she's in trial. Okay. One more little sip. And I'm a loud drinker, so forgive me. A little clearing of the throat. Wisconsin's Preservation of Biological Evidence Statute. Wisconsin Statute 968.205, 2001, amended 2005. Let's stop there. In 2001, Mr. Fallon, was indeed part of this statute and creating it. So he is one of the few people that cannot say, "Hey, I didn't know about this law," because he helped create it. So here we go. Governs the preservation of physical evidence collected subject to criminal investigation. Number two, except as provided in subsection 3, if physical evidence that is in the possession of the law enforcement agency includes any biological material that was collected in connection with a criminal investigation that resulted in a criminal conviction, and the biological material is from a victim of the offense that was subject of the criminal investigation, or may reasonably be used to incriminate or exculpate any person for the offense, the law enforcement agency shall preserve the physical evidence until every person in custody as a result of the conviction has reached his or her discharge date. So we don't have that. Let's stop there. We don't have that. We still have individuals that are incarcerated. The bones were used to incarcerate them. It was the actual evidence, the physical evidence used. Are the bones biological? Absolutely. So that's where we have the problem. We have the violation right there. It goes on to say in subsection 2M, a law enforcement agency shall retain evidence to which subjects to applies in an amount and manner sufficient to develop a DAP as defined in 939.74 from the biological material contained in or included on the evidence. We go on to 3. Subject to subsection 5. A law enforcement agency may destroy evidence that includes biological material before the expiration of the time period specified in subsection if all of the following apply. A. The law enforcement agency sends a notice of its intent to destroy the evidence to all persons who remain in custody as a result of criminal conviction, and to either the attorney of record for each person in the custody of the state public defender. Let's stop there. So, we've already double checked, and so has Zellner. Were the individuals that are incarcerated, which at this point we have Brendan Dassey and we have Steve Avery in prison, were they asked? No. And were the attorney of records asked? We've already got that's why she's going through the post conviction lawyer, the Hagel Payne and Askin lawyers, the attorneys. She's asking them, did you get notified? And they're saying no. So we have further violation of the same law. Let's see if the other stipulations, because all of these have to be met. So already we've got, 3 check marks we've got to have cleared off here, and we're missing A. They did not do that. They're lacking check mark A. So check mark B, what do we need? No person who is notified under partition A does either of the following within 90 days after the date on which the person received the notice. 1. Files a motion for testing of evidence under 974.07, or 2. Submits a written request for retention of the evidence to the law enforcement agency. So let's think about that. We have this before the expiration of the time period. Okay, they can destroy it if all these are met. No person has been notified of. Okay, so it's saying if there's a motion filed for testing of the evidence, you can't do anything with destruction of that evidence. So if the motion is that we're or even they submit a written request for retention of the evidence, then you can't destroy it either. We're missing that box because we already did that. We submitted that we wanted to test the evidence. Though it was denied, we still submitted through Hogopane that we wanted to test the evidence. So they couldn't have destroyed it based on that if they were being legal. And C, no other provision of the federal state law requires a law enforcement agency to retain the evidence. We obviously see that they're being required to retain the evidence. So it is beyond question the state violated 968.205 205 when it failed to 1. Preserve the human bone evidence, and 2. Notify Mr. Avery and Miss Hagelpain of its intent to do the same because the human bone fragments were biological evidence collected in the course of the state's investigation of Mr. Avery, which ultimately led to his conviction. The purpose of the September 20, 2011 meeting was to identify the human bone fragments of Miss Halbach and return them to the Halbach family. Therefore, the human bone fragments recovered from the gravel pit are properly considered within the ambit of 968.205. So, what she means there, you guys, is the bone fragments that we're specifically talking about, which are the pelvic bones, specifically qualify for the retention law to protect them. Because we continue, because let's get it up there, because 968.205 does not provide a remedy for convicted persons in the event of a violation. Fashioning a remedy is left to the courts, an action Wisconsin courts have yet to take. So this is very important because Wisconsin could be set in history here because we have yet to see Wisconsin to have to ever address this. Mr. Avery submits that this court should establish the most just and most logical remedy for such evidence preservation violations. Such violations amount to per se due process violations. This conclusion is borne out by controlling United States Supreme Court precedent addressing evidence preservation violations. And she goes on to reference California versus Trombetti and Youngblood versus Arizona. Taken together, Trombetti and Youngblood comprise the list of constitutional jurisprudence that outlines the extent of the state's duty to preserve evidence. Youngblood 48 U.S., Trombetti 46.7 U.S. In each case, the United States Supreme Court promulgated, oh boy, you guys, brace it, because this is a big word for me. Promulgated a test to determine whether destruction of evidence violates criminal defendants' due process rights. ID. The Trombetti test focuses on the probative value of the destroyed evidence and whether the evidence possessed exculpatory value that was apparent before its destruction. The Youngblood test, for its part, disregards the probative value of the evidence in favor of examining the government's role in the circumstance that led to the destruction of the evidence. If a criminal defendant can satisfy either test, then a court will rule the destruction of the evidence was a violation of due process and reverse the defendant's conviction. And she again uses Youngblood and Trombetta. The Due Process Clause of the 14th Amendment of the United States Constitution imposes a duty on the state to preserve exculpatory evidence. The state's failure to preserve evidence violates and defendants' due process rights if police 1. Failed to preserve evidence that is apparently exculpatory, or 2. Acted in bad faith by failing to preserve evidence that is potentially exculpatory. While the United States Supreme Court did not clearly state whether the Youngblood test overruled the Trombetti test, Wisconsin courts view Youngblood as a separate test that complements the Trombetti. So let's stop there. What she's validating here is that we have two tests. They're a little bit different, and that was the Youngblood test and the Trombetti test. Now, the Youngblood test, it tends to, let's see, determine whether, okay, I think it is that the young blood is complementing. In other words, it's backing up the same as the Trombetti test. Even though they're two different tests, we have one complement the other. And so both are coming to the same agreement. And we continue. In Greenwald 2, the Wisconsin Court of Appeals set forth the approach to the Youngblood and Trombetta tests after examining the difference between the two tests. Because Youngblood added a bad faith determination to the Trombetti materiality inquiry, the Greenwald Court reasoned that the Supreme Court intended to create two complementary preservations of evidence tests. The Greenwald II court synthesized a two-step analysis to address the destruction of evidence. The outcome of this analysis depends upon two specific examinations. Number one, whether by looking at the facts surrounding the case itself or destroy evidence was apparently exculpatory or potentially exculpatory. And two, if the evidence is merely potentially exculpatory, whether the destruction of the evidence results from the governor's bad faith. So, bad faith is basically saying that they knew what they were doing wasn't correct. It wasn't right. It's premeditated and they know it's not right. And so that's what she's trying to establish here. We'll go ahead and read on. Thus, in Wisconsin, the adoption of either trombetta or young blood depends upon the probative value of the evidence at issue. If the destroyed evidence is apparently exculpatory, Wisconsin courts will apply the Trombetti test. See also Youngblood. She has in parentheses here to invoke Trombetti, a defendant must demonstrate that the government destroyed evidence possessing an apparent exculpatory value. However, to trigger the Youngblood test, all that is need to be shown is the government destroyed potentially exculpatory evidence. Wisconsin courts have followed this line of reasoning. For example, the Court of Appeals stated in State versus Parker, a defendant's due process I'm sorry, a defendant's due process rights are violated by the destruction of evidence if the evidence destroyed was apparently exculpatory and of such a nature that the defendant would be unable to obtain comparable evidence by other reasonable means. Or two, if the evidence was potentially exculpatory and was destroyed in bad faith. Let's stop there for a minute. Remember the bullet, you guys? That was very much exculpatory evidence. And we had one shot at it, we were told. Well, we're going to be doing a video. We have a gentleman that is, I can't say it very good, a biological molecular biologist. That was it. Anyway, he's come on team to the RD team, and he'll dig into that later. But right there, you have that same situation. You got one shot. We can't replace these bones and still test and do the things we need to get Stephen and Brendan out of prison. We only have the shot at these bones, the pelvic bone specifically. It can't just be any bone, it has to be the pelvic bone. And it has to do with the undermining of the verdict of the jury because they were fed and spoon fed that it had to be him. It was all on his personal property. Nobody else would have the ease of access to get to these bones and put them there. And so therefore it absolutely was Steve Avery. We get the Denny law evoked, which means we can't point to anybody else. It's all on Steve's property. But the pelvic bones weren't. They weren't on Steve Avery's property. They were not in the burn barrel, the Dassey Yonda burn barrel. Where were the bones? The pelvic bones were down in the quarry. And Kratz said not 20 seconds was he going to spend on those bones because, don't worry about those bones, huh? Why? Because it didn't fit the narration that the state was having to feed, that they were feeding the jury. And so it's very, very important that you understand that it is very specifically the pelvic bones. And that's why they're very apparent that they are exculpatory. They are worth evidence. There's a lot of information we could be basing people remaining a lifetime in prison because we don't have those bones and we can't prove anything. Or we're honest and we say, hey, this isn't right. We don't even have the bones so he can prove his innocence. All right. I'm getting off my little soapbox and we'll continue. Sorry about that. I just wanted to interject a little bit. While the Trombetti Youngblood evidence preserves doctrines originally applied only when evidence was destroyed pretrial, the Wisconsin Court of Appeals stated that Trombetta and Youngblood and Wisconsin's two-part Greenwald test are applicable to the post-conviction destruction of evidence in Parker 2002. And then parentheses, there is a long line of cases addressing the pretrial destruction of evidence and the defendant's due process rights. We see no reason why this line of cases should not apply to the post-conviction challenge to the post-conviction destruction of evidence. So what we're saying there basically is what's good for the goose is good for the gander. If it worked, if they've applied the rules to pre-trial, why wouldn't they apply the rules to post-trial, post-conviction? And continued. Mr. Avery submits that following Parker, the Greenwald 2 two-part analysis should be applied to address the state's violation of the DNA evidence preservation statute in the instant case. And we continue. When examining the test set forth in Greenwald 2, Wisconsin's court apply certain presumptions implicit in the DNA preservation statutes by codifying a right to the preservation and testing as provided in Wisconsin Statute 974.06 of evidence. The DNA preservation statutes create three presumptions regarding both materiality of the evidence and the circumstances surrounding the destruction or loss. All right, let's take just a moment to take a break, get a drink on the materiality, and we will continue. I'll check in with you on chat a little bit, see how everybody's doing. Sorry, I'm drinking and you can hear me and I drink loud, so I'm going to mute the mic for a minute. Now, I want to take a moment here. I'm before we jump right back in. We're about halfway through the document, so we're going to take about 2 or 3 minutes here. If you need to take a break, a little intermission here while we do. I'm going to be typing this address for you. This is to the library, and you can click this, and you will see that this document is indeed there. Help yourself and follow along. We are going to be rejoining in a moment on page 21. All right, welcome back to Making a Murder, My Journal, and we are starting the second part. And this is a supplemental motion filed by Zellner, 974.06. Materiality. First, the statutes, excuse me. First, the statutes presume that all biological evidence collected in the course of a criminal investigation and covered by the statutes is material. The the applicability of either trombetta or young blood depends upon the materiality of the evidence that was lost or destroyed. A hurdle to applying these tests is the impossibility of knowing definitively the material value of the evidence that no longer exists. The Supreme Court in Trombetta addressed the difficulty of extra, oh boy, big one, extrapolating. Sorry, guys. You know, I'm just a housewife. Please don't be hard on me. Please be kind. Extrapolating materiality from lost evidence. Courts face the treacherous task of divining the import of materials whose contents are unknown and very often disputed. So let's stop there and discuss that. If you don't have it to show it, to test it, how can you make your point? Right? So you can explain to somebody exactly how you want to build your house, but if you don't have the blueprints, what are they really going to build? So that's what you got to do is you've got to build this story in the jury's mind in a retrial. And we need the bones to test to be able to put that blueprint in their head properly. And we can't base it off just guesswork. We need the pelvic bones to do this, and the pelvic bones have been given away to the family. So if you're just tuning in on the second half, that is the complication. And we have been granted a fact finding hearing here. And this is Zellner's, Steve Avery's post conviction lawyer addressing this. And here we go. And we continue. Excuse me. However, in the context of addressing the materiality of evidence lost or destroyed in the violation of Wisconsin Statute 968.205, the Wisconsin legislature has already resolved that problem, especially when considering together with 974.07 that DNA evidence preservation statute demonstrates the Wisconsin legislature recognition of the importance of post-conviction DNA testing. These statutes, taken together, provide for the preservation of biological evidence and, in many instances, DNA analysis thereof. The codified right to DNA preservation and testing shows the legislative intent to ensure that DNA testing of biological evidence plays, quote, a significant role in the suspect's defense, unquote, and efforts to obtain post conviction relief. Therefore, the Wisconsin legislature, through the DNA preservation statute, has placed preserved biological evidence in the class of evidence the United States Supreme Court deemed material as defined in the Trombetti and Youngblood. B. Potentially exculpatory evidence preserved under Wisconsin Statute 968.205. Second, following from this presumption of materiality, the DNA evidence preservation statutes further presume that in every case, biological evidence collected in the course of the criminal investigation is at least potentially exculpatory, as defined in Greenwald 2. In the context of DNA evidence, apparently exculpatory, my nemesis there, evidence contemplates instances where results from testing or retesting of the biological evidence that eluded the petitioner would exonerate him or her of the crime of conviction. So that's very important, you guys. Stepping away for a minute. What they're saying is, yeah, we've seen other historical cases where the biological evidence was used in post conviction through tests and of that nature. Um, to free the person, to exonerate them, set them free, walk out that jail the next day or that day. And so this is huge that the bones are not there for us. And in continuing, similarly, potentially exculpatory DNA evidence refers to evidence in cases where, quote, if subjected to DNA testing or retesting, exclusionary results would support the petitioner's claim of innocence, end quote. In line with the Supreme Court's reasoning of Youngblood, this category includes evidence that was simply an avenue of investigation that might have led in any number of directions, unquote, and evidence about which, quote, no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant, end quote. These categorical requirements for potentially exculpatory evidence necessarily apply to biological evidence covered by the DNA evidence preservation statute because preserved evidence tests results allow reasonable persons to disagree as to whether the results of the DNA testing rule out the possibility of guilt or raise a reasonable doubt of guilt. Youngblood 48. Therefore, evidence covered under the Biological Evidence Preservation Statute must be deemed at least potentially exculpatory, and the loss or destruction of such evidence triggers, at minimum, the Youngblood due to process analysis. C. The DNA evidence preservation statute presumes that every violation thereof constitutes bad faith. Now let's stop there a minute. Bad faith, you get this from the young blood. So the other case was more or less that this had occurred, this action had occurred, destruction of the evidence. But what the young blood it presents, this case, is that it was knowingly done when the evidence was still needed. So they are of knowing that they're breaking the law. It's done in a negligent way. Intent, I guess, is a really good way. Bad faith is the way that Miss Zellner has chosen, as well as Youngblood, to follow this. And we continue. Lastly, because the statutes prescribe the normal course of conduct for Wisconsin law enforcement agencies regarding collection, preservation, and eventually destruction of biological evidence, every violation of the statutes constitutes quote unquote bad faith, as defined by Youngblood and Greenwald 2. The young blood court reasoned I'm sorry, let me start this over. I got tongue tied. The young blood court reasoned that law enforcement agencies suggesting bad faith arise when the police themselves, by their conduct, indicate that the evidence could form a basis for exonerating the defendant. Let's stop there a minute. Whoa. So, what she just put in this form is that when she sees the case with Youngblood, it puts a suggestion out there that their intent is that they feel the police themselves feel that they are worried that this evidence could exonerate the defendant if it's reevaluated. And so rather than risk the defendant getting exonerated in bad faith, in other words, knowingly, they get rid of the evidence by destruction. These are strong words, you guys. And we continue. This consideration in turn hinges, quote unquote, on the police's knowledge of the exculpatory value of the evidence at the time it was lost or destroyed, end quote. In these cases, bad faith exists when the conduct of the police is outside the scope of normal practice. The Youngblood Court's definition of bad faith takes for granted that there are times when the police will not know whether evidence was material before it's lost or destruction. The DNA preservation statute eliminates this assumption by creating an affirmative duty to preserve all biological evidence taken from the crime scene. Thus, law enforcement agencies are on notice that biological evidence is deemed important to the successful administration of the criminal justice and therefore may not claim ignorance that oh, this is so good, you guys. I'm sorry. May not claim ignorance that the destroyed evidence was at least potentially exculpatory. She's nailing this. She is so brilliant. And we continue. I'll take just a few minutes. I do need to grab a drink. I'm so excited, you guys, in reading this. I'm sorry. I got to do a little happy dance because it's saying that they knew what they were doing and they're going to have to be addressing this. The appellate court is telling them, you have to address this. You cannot no longer ignore what is being said, nor can you claim that it's a new topic. So I'll be right back. Just going to grab a drink and gather my wits so that I don't get too excited and start stumbling on my words. Okay, here we go. Wisconsin Statute 968.205 imposes certain duties upon law enforcement agencies. At the most basic level, the state bears a duty to preserve all biological evidence collected during the course of an investigation that leads to a conviction. Additionally, the statute sets forth the steps the state must take before lawfully destroying such evidence in its possession. Because a violation of the DNA preservation statute means the state did not abide by either the requirements for preservation or for the proper destruction of the evidence as required by law, such conduct constitutes bad faith. This conclusion is not undermined by the Wisconsin Court of Appeals adoption of the official amnes standard in the Greenwald 2. The Greenwald 2 court emphasizes that bad faith does not exist when the destruction of evidence was due to inadvertent or negligent action on the part of the law enforcement. However, this exclusion only pertains to the two situations where evidence preservation was: one, required by non codified law enforcement agency policy, or two, not required by any policy. Mr. Avery submits that the violation of the state law goes far beyond the negligence standard that the official animus framework was formulated to replace. That is, a violation of state law should not be analyzed within the context of mere negligence or inadvertence. Indeed, such a violation should immediately trigger official amnesty as adopted in Greenwald 2 as per C showing of bad faith under Youngblood. The state was aware of the apparent exculpatory value and materiality of the bones prior to their destruction because of the pretrial FBI examination, trial stipulation, and April 4th, 2007 order. This is big, guys. This is where she sinks this in. The apparent exculpatory value and materiality of the bones was apparent to the state prior to the destruction, as it is demonstrated by its efforts to conduct DNA examination of the bones pre trial. That examination by the FBI was unsuccessful at that point in time. The parties entered into a stipulation at trial, which stated that the FBI conducted no DNA examination of the possible human bones from the quarry pile south of the Avery salvage yard due to the degraded condition of the bone fragments. Both the apparent exculpatory value and materiality of the bones was established and would have been apparent to the state prior to the destruction by the attempted FBI testing and the stipulation between both parties, which was entered at Mr. Avery's trial. Post trial, the state was aware of the apparent exculpatory value and materiality of the bones prior to their destruction when the trial court entered an order on April 4th, 2007 for the preservation of blood evidence and independent defense testing. This order contemplates and allows future DNA testing by Mr. Avery. Stop there. You guys, what she's saying is not only is it that we could just basically, there is no excuse for any destruction of biological evidence for any reason unless all parties are agreed. So you can't say I didn't know that, I shouldn't have done that, I thought in this case I could do it. No, not at all. Furthermore, they have put a stipulation in the trial itself that these bones would be future needed to test for DNA testing, and both parties agreed to this at the end of the trial. So the state agreed that they would know that these bones were important and that that could come up in the future. So they've got their backs to the wall. That's where we are. Let's go ahead and continue this. In its order, the trial court gave Mr. Avery the opportunity to, at any time, submit items of evidence for DNA testing. Both the apparent exculpatory value and materiality of the bones was established by the April 4th, 2007 order. So Mr. Avery has covered his butt. Very well. D. Application. The presumptions created by the DNA evidence preservation statute shape the analysis that Wisconsin courts should undertake when confronted with instances Sorry. Such as in the instant case where a law enforcement agency violated the statute. This analysis is grounded in the two-part test set forth in Greenwald 2. However, it differs to the extent Wisconsin court apply the presumptions created by the DNA evidence preservation statute. These presumptions, as set forth above, dictate issues at the heart of the test. Wow, this is just incredible. Excuse me. Trombetti's apparently exculpatory requirement is met. As described more fully above, the first step in the Greenwald 2 analysis is an inquiry into the first two steps of the Trombetta test, whether the destroyed evidence was apparently exculpatory. Greenwood 2, 189, Wisconsin 2D at 67, Trombetti 47 US 48, 488, 89. This examination asks whether, if the destroyed evidence was subjected to testing or retesting, favorable results would exonerate the petitioner, and whether the state was on notice of this fact. If the state failed to preserve evidence that was apparently exculpatory, and if the state was aware of its apparent exculpatory nature, then the court must vacate the conviction. Trombetti 46 US 48 488 89. As stated previously, the apparent exculpatory value of the bones has been demonstrated by the state's efforts pre-trial to have the FBI test the bones in the subsequent stipulation and April 4th, 2007 order. Very good, very good. Youngblood's potentially exculpatory combined with bad faith requirement is met. So now she's showing you how all these requirements are met. Now the one for the trombetta was just that they did it and that they shouldn't have. This one is that they intentionally premeditated, that they knew they were stepping outside of the normal law and they knew that this was not the correct path to take. So that's where Youngblood comes in. It implies bad faith. And here we go. We continue. If, however, the evidence is not deemed apparently exculpatory, then Wisconsin courts should apply the Youngblood test under the second step of the Greenwald 2 analysis. Youngblood 48 US 5658. Greenwald 2 189 Wisconsin 2D at 6768. Alternatively, under the Youngblood test, courts would examine whether the evidence was potentially exculpatory, and if so, whether the police acted in bad faith when they destroyed the evidence. In light of the presumptions created by the DNA evidence preservation statute, the trial stipulation, the pretrial FBI examination, and the April 4th, 2007 order, as described fully above, mandates that the evidence be considered potentially exculpatory. She's nailed it. She's using the law to literally, if this is a chessboard right now, yeah, she is getting them cornered very well in this game. Wow, this is just, she's nailing it. Impressive. Next, the court considers whether the law enforcement agency acted in bad faith. As set forth above, the presence of bad faith is presumed every time the Wisconsin Statute 968.205 DNA evidence preservation statute is violated. Here, the failure to give notice to Mr. Avery and to his attorneys violated the statute. Additionally, the state violated the April 4th, 2007 trial court order by giving the bones back to the Halbach family. By returning the gravel pit bones to the Halbach family, the state has admitted that the bones are human and that they belong to Miss Halbach. The state cannot credibly argue that it returned animal bones to the Halbach family for burial or cremation. Both of these violations mean that the state acted outside the scope of its normal practice by destroying evidence it knew had to be preserved in compliance with Wisconsin Statute 968.205 and the April 4th, 2007 trial court order. The state's ongoing efforts to conceal the destruction of bones. As previously discussed, Mr. Avery filed a motion to stay appeal and remand the cause for new scientific testing of the gravel pit bones. When the state responded to Mr. Avery's motion, it never mentioned that it had effectively destroyed the bones that would have been tested had the motion been granted. On February 25th, 2019, the appellate court ordered notice that The state's objection does not address the merits of Avery's claimed statutory and constitutional violation, as it has not responded to Avery's supplemental filing alleging the possible destruction of evidentiary items which it appears the parties previously agreed to preserve. Nutshell right there for you. They totally agreed. Yep, we're gonna watch over these bones right here. Don't worry, you get all your ducks in a row. We got the bones right here. All right. Miss Zellner walks in. Yep, time to test the bones. We got all our ducks in a row. Let's test the bones. What do you mean we're missing the bones? Where are the bones? Now I just need the Corey ones, the ones that are possible human, that were of no consequence to you or the trial or anything. Yeah, I just want those bones to test. Where are they? I thought they were possible human bones. What do you mean you gave them back to the family? If they're not human bones, you wouldn't have given them back to the family. See? So that's my little soapbox. Let's get back onto track here. Sorry about that. Just a moment of my frustration coming out. Exhibit 8, page 2. We are on page 23. If you follow along, you can go to rubberduckystevenaveryfiles.com and you'll see the little tutorial how to work the library. And on the right side of that, there is a link there. You can click the little framed picture of this. It'll take you right to this case. You choose 23. You're right with us to read along. Both of the state's responses indicate bad faith and a lack of candor in failing to address the destruction of the gravel pit bones without informing Mr. Avery, his attorneys, and the court. It does say here in a little paraphrase here in parentheses 1228 2018 response in opposition to the petition to stay the appeal and remand this case to the circuit court is attached and incorporated herein. The state also agreed in a September 18th, 2017. Now keep in mind, September 20th, 2011, they've already given the bones away. They don't even have them. So let's read this carefully because we're looking at, 6 years later. State also agreed in September 18, 2017, meeting with current post conviction counsel to arrange for the testing of the suspected human pelvic bone. Now, it didn't just say bones, you guys. It's talking about the bone we need, the pelvic bone. They're agreeing to it and they're going to arrange for the testing. Talk about bad faith, you guys. Wow. Continuing, it is clear that the parties have construed the scope of the April 2007 order to permit testing of a variety of biological samples deemed relevant to the instant case. The state was on notice of this agreement in September 2011 when it ineffectuated the destruction of human bone fragments recovered in the gravel pit. The state knew it bore a duty to preserve biological material at the time it ineffectuated the potential destruction of the human bone fragments without notifying Mr. Avery and his attorneys. The state, by taking these actions, acted in, say it with me, guys, bad faith, and with official amnesty, as defined by Youngblood and Greenwald II, United States. Parentheses here, you guys, finding bad faith where government actors destroyed potentially exculpatory evidence when they were on notice that the evidence at issue should be preserved. Again, another parenthesis, finding bad faith where law enforcement agencies destroyed evidence they knew the defendants asked to preserve. And in continuation, in light of the information that the pelvic bone, parentheses, Calumet County Sheriff's Department, tag 8675, was categorized as human and therefore would have been returned to the Halbach family. Undersigned counsel made two urgent email requests of Prosecutor Fallon for confirmation of its whereabouts to call undersigned counsel immediately on her cell phone to confirm whether or not the state was in possession of the human pelvic bone property tag 8675. Mr. Fallon has has consistently represented to undersigned counsel for the last 3 years that the state was in possession of the pelvic bone. Prosecutor Fallon never returned Mrs. Zellner's telephone call and apparently was instructed not to do so by his co counsel. Could that be attorney Mark Williams? Mr. Williams who inadvertently called current post-conviction counsel cell phone at 9:13 a.m. on February 13, 2019, and left a message intended for Prosecutor Fallon, which stated, and I read, you guys, "Hi, Tom. This is Mark Williams. I'll send you an email later today, but I don't think we should do anything or respond to her at all until tomorrow. When we look in the bag and see exactly the pelvic bones are in there or not. So I would not respond to her until we look into the bag tomorrow morning, and then we can talk about it before we send a response. Thank you. Bye." And on that note, we continue on. On February 17th, 2019, Prosecutor Fallon left a voicemail on current post conviction counsel's cell phone, admitting, yeah, many bone fragments were returned to the family. CD with Attorney Williams 213, 2019, and Prosecutor Fallon's 2019 voicemails is attached and incorporated herein. All right, we're going to go ahead, take just a breather here, wet my whistle. We're going to take about 2 minutes. We are on page 29 of 49. We're not quite three-fourths of the way there, but we are climbing. So I'm going to check in with chat, just see if we have any big questions. If you are wanting to follow along, this is our longest video that we've ever made, of course, and you can still jump in. Go to that Rubber Ducky Stephen Avery files.com. You click right on the framed picture there. It'll take right to this document. You'll be able to follow along. So we're going to have a 2-minute little break here. I got to catch my breath. I feel like an auctioneer with all this air going through my lungs. So I just need a minute and we'll go forward. So I just played that for you guys. I don't know if you were able to hear it or not. That was the actual call. That was the butt dial, if you will, for lack of better words, where he accidentally dials Zellner. And that was Fallon's lawyer, Mr. Mark Williams, who called to basically, in my personal humble opinion, and that's all it is to try to allow them to say they didn't know that they gave the bones away. But as we just read in this, that's not going to cut it because it doesn't matter what you think your excuse is. The state law states that you do not get to give away any biological bones. I'm not sure how to play it for you guys on here. I tried. I, it's not really a butt dial. He actually dialed Zellner correct. I was just saying, for lack of better words. Um, Ron is really trying to get me to play that for you guys. Unfortunately, I would have to hook up Discord to be able to do it, and it would get into the mix of the whole thing. So I tried to play it on my phone. It didn't work. I apologize, but we will have that posted in the library, and you will be able to. It isn't the butt call, it's Tom Fallon. Hmm. I'm not sure, Bron. From what I understood, it was Mark Williams that is the lawyer calling Tom Fallon, but he actually called Zellner instead. Is that correct? Oh, it's Tom Fallon saying that, not the lawyer? Okay, thank you for correcting that. So apparently it is not Mark Williams, which is what I had always been led to believe. I appreciate the correction very much. That way I get the truth out there for everybody. Um, Before we get going on this document, I would like to just address something. There was a lady named Ellen Derricks that has hit up my channel, and she is very displeased with me because she claims that on my last video, I stated that the Uyghur I'm sorry, I've got weird on my brain, that the White Funeral Home as well as the Pfeiffer Funeral Home are not the same. That Carmen Botwell was at the Manitowoc Pfeiffer Funeral Home, and that the Whiting Funeral Home is in, I believe, Chilton, that they are not affiliated. And I would like to state that we have done our research and we do not find an affiliation. So we will give her that because we are willing and very ready to walk in the truth. But that being said, she also tweeted that she went to school with Jerry Pagel, and we have the RD researchers have researched this thoroughly and cannot find her in any school book whatsoever associated with Jerry Pagel, Sheriff Jerry Pagel. In fact, we found her registered to a completely different school that had nothing to do with it, as well as there were many, many years between their ages that would also lead us to believe, in our personal opinion, it's just our humble opinion, that she had nothing to do with Jerry Pagel in school. So, apparently, her family owned the funeral home, the Whiting Funeral Home that did get Teresa's bones in the end. However, they did not own it at the time of the transfer of the bones. They actually, her father, Earl Pfeiffer, sold it to the Whiting family many years before the bones were transferred over to the Whiting Funeral Home. And she is just a concerned party that has been hitting up my channel, calling me a coward and all kinds of names. She posted, and within 5 days, I wasn't able to get all the research done, and neither were the rubber duckies. And so we took our time, and she's very, very upset with us. So it's okay she's upset. It's okay to be angry. We're all good with that. We're going to take our time when we're researching things. We do not speak improperly to our knowledge. We were reading directly off a hardcore source, which is the Pfeiffer Funeral Home. um, Actually, it was the Whiting Funeral Home. I misspoke. Actual website themselves on their own public page. So we weren't quoting this off of some just generic form of some newspaper. We were reading it off their actual website. So that's the I promised her I would make that statement on my next live video, and so there you have. All right, let's jump back in, guys, and here we go. Mr. Avery's expert, Doctors Dehane and Symes and Selden. Forgive me if I pronounce these names wrong. I have not been given these names prior. Dr. Dehane establishes that the bones were planted in Mr. Avery's burn pit. Current post conviction counsel has developed new evidence through her expert, Dr. John Dehane. who has ruled out, based upon new discoveries in forensic fire science, that Mrs. Halbach's body was burned in Mr. Avery's burn pit. Additionally, Dr. Dehane has demonstrated that the bones were planted in Mr. Avery's burn pit. This evidence also meets the Trombetti requirement of apparently exculpatory. Therefore, Dr. Dehane's opinions greatly increase the evidence of Mr. Avery's actual innocence and make the destruction of the gravel pit human bone fragments even more, oh boy, you guys help me, egregious constitutional violation. Um, let's see. Dr. Symes has identified human bones in the gravel pit. Another expert of current post conviction counsel, Dr. Stephen Symes, a renowned forensic anthropologist, has offered the opinion that Dr. Eisenberg correctly determined in her second anthropological report, see Group Exhibit 10, that the gravel pit bones were human based on her visual inspections of the bones. Dr. Symes has also been able to identify human ribs and additional human pelvic bones from Calumet County Sheriff's Department items property tag 7411 and property tag 7412. Dr. Selden establishes the state's bad faith by commingling the bones when they were returned to the Halbach family. Mr. Avery's expert, Richard Selden, MD, PhD, Dr. Selden, has offered the following opinions regarding the commingling effect of the bones. Number one, because the bones were commingled and their labels removed, it is no longer possible to determine if the victim's bones were present in the gravel pit or if the bones were in the gravel pit were human. Furthermore, presuming the commingling bones included those from the gravel pit were cremated, and the ability to generate a DNA ID has been ooh, irrevocably, nope, that's not the word. You guys help me out. Irreversibly lost because following cremation, the sizes of the boy, I should have practiced this. I sound dumb. I'm sorry, you guys. Genomic DNA fragments are too small to yield amplified DNA of the size required. The evidentiary value of testing has been destroyed. So they've mixed up the bones. We don't know where any of them came from. It really has a mess, and now we don't even have the bones. Alternatively, presuming the commingled bones, including those from the gravel pit, were buried, the DNA itself has likely been destroyed due to environmental conditions and microbial degradation over the last 8 years. As noted in the proceedings paragraph, even if such tests could be done, it would be useless because the bones from all three sites were commingled. Number four, testing results would be scientifically invalid because the controlled conditions, including but not limited to a clear understanding of the location of each bone fragment, were lost by the actions of the state on September 20th, 2011, in disposing, mingling, and destroying the human bones. Dr. Selden also notes in his affidavit that advances in this last several months have resulted in the development of even more sensitive DNA testing that allows a fraction of DNA from the single cell to be identified as being a human origin. The opportunity to perform scientific testing to definitively confirm the state's forensic anthropologist's determination that the bones were human has been irrevocably lost, all of the above stated reasons. Dr. Selden establishes that more accurate and probative results could have been obtained from the gravel pit bones with newly developed DNA technology. As stated in his previous affidavit, Dr. Selden opined there would have been a quote unquote reasonable likelihood of more accurate and probative results, that the gravel pit samples would generate DNA identifications if processed using A&D rapid DNA technologies. Dr. Selden has offered specific details about the improvement in the DNA technology that would have resulted in a DNA identification being made of the gravel pit bones. Let's stop there for a minute. You know, if we had the bones to test, the pelvic bones in the quarry, and those bones came back Teresa's, right there, we could prove, we'd have so much of a chance to prove that the entire jury, the verdict of the jury was completely undermined because they were fed the wrong story. They were fed that only Steve Avery could be looked at because it was all private to him on his private property. The key was in his trailer, the RAV right by his trailer, the bones right by his backside by his garage. It's all about Steven. Yeah, but it's not though if those bones are in the Corey or Teresa's. So how do we go forward? Let's continue to read on what Dr. Selden has offered. And continuing, number 7, my understanding is that in 2006, the FBI determined that performing DNA analysis, including mitochondrial DNA analysis on the bones in the instant case, would not be effective due to the degraded nature of the remains. I believe the decision to defer DNA testing was reasonable at the time because then current technology was unlikely to be successful. Number 8. Today, the decision to defer testing has not, I'm sorry, testing has been validated. DNA identification technology is dramatically improved as compared to the state of the art in 2006. And my expectation, as originally presented in my affidavit of 17 December 2018, is that this improved technology will allow the successful DNA typing of the bone in instant case. There are three major advances that lead me to this conclusion. Number 9. First, DNA typing technology is general, and the ANDE system, in particular, are much more sensitive than was the case in 2006. Improved short tandem repeat primer design and synthesis, improved amplification reaction mixes, and better controlled thermal cyclers combined to dramatically reduce the limit of detection as compared to 13 years ago. As approximately 2014, picogram quantities of the geometric DNA can now be readily and routinely detected, at least a 50-fold improvement over 2006 state of the art. Number 10. Second, the ability of degraded DNA to be analyzed has been significantly enhanced over the past 13 years. These advances have been driven in large part by the FBI's 2017 requirement to utilize 20 CODIS STR markers instead of 13. The addition of the new CODIS STR markers and the mini STR markers include those that can identify smaller, more highly degraded DNA fragments than in 2006. Let's stop there for a minute. This is huge. So we were dealing with 7 Loki, and they're trying to tell us they've identified this person. Sherry's like, well, 7 Loki. Sherry Colhane from the Wisconsin State Crime Lab. 7 loci match Teresa Halbach. 7. Yep, yep, yep. But the state had given this to the FBI, and the FBI did not say that they matched Teresa. They said, we cannot rule her out. Now, had the FBI continued, they would have literally been able to say, and we can't rule out some other people too. See the problem? And this one in 800 million billion trillion that Sherry Culhane's talking about is unheard of. It's not a true statement at all. And the proof is in the pudding when the CODES has been pushed up to 20 loci. When you get those strands and you're talking about 20 plus, you are really nailing the markers. So when you look at the mini STR markers that he's referring to, it's like they have the ability basically to test this in such a high sensitive manner that they can get down in there and see even the tiny, tiny, tiny little bitty markers to see if they match as well. So we have a highly, highly sensitive test that can now do as they're quoting, 50-fold um, better, more improved than 2006. All right, let's continue with number 11. Third, the ANDE system is much more rapid than the conventional laboratory bone processing today, let alone that of 2006. The ANDE allows results to be generated in less than 2 hours as compared to the months to years characteristics of the conventional processing. One of the major advantages of speed is that it allows many more bone samples in the instant case to be processed essentially immediately. If we assume, for example, that we process 12 samples during the first day, the results from the work will inform the approach to the processes, the next set of samples on the following day. This immediate feedback allows forensic DNA identification to be optimized in real time. was not possible in 2006. In that era, results might become available months to years later, far too long to have a practical impact on sample processing optimization. Again, for the reasons noted above, it was highly unlikely that in 2006 technology could yield useful results from any circumstance. So you guys stop there. In 2006, if they're waiting years, how long are we going to hold the court case up? you know we're going to have somebody sit in prison while we decide if the test results are accurate enough at that timeline, if we need to retest or go forth and all this. They're sitting there waiting. The families are waiting for an answer. We cannot hold the court systems up on this risky idea that we might have a DNA sample from degraded bones in the years to come. Now we're looking at this case, we can do it in a matter of hours. So speed is of the essence. That means that we can have instantaneous results that can actually affect the case that's at hand. And continuing. In continuing, number 12, on June 4th, 2018, the ANDE Rapid DNA Testing DNA ID system received National DNA Index Systems NDIS approval from the FBI. The approval allows all accredited forensic DNA laboratories to utilize the A&E system for the process of buccal swabs and to submit DNA ID data to the federal DNA database CODIS and to search the federal DNA database with the data generated from the A&E system. The FBI has publicly stated that it intends to allow the NDIS approved rapid DNA systems to be used to test arrestees while in custody excuse me, in police booking stations as required by Federal Rapid DNA Act of 2017, passed unanimously in the House of Representatives and Senate. A peer reviewed manuscript describing this NDIS approval study was published in Forensic Science International Genetics in February 2019. Let's just stop there for a minute. Now, in 2006, we had an audit take place that Buting cited many, many things that he had read, such as at the Wisconsin State Crime Lab, where all the Stephen Avery evidence was being processed in 2006. There was an audit that took place, and one of the audit sightings was that the NDIS system, which is referred right here, which is the National DNA Index System that the FBI uses, the CODIS, the data bank for the CODIS, was not being regulated at up to 12 to 14 stations, and that non DNA forensics analysis had access to it. Pretty much anybody visiting the lab had access to it. That's a pretty big deal when that system, once you're in it, if you match it and that match is related to a crime, you could be in prison the rest of your life and be innocent. And they were not watching that at our state crime lab in Wisconsin. So that got corrected. But what you have to wonder is, what other sites did they have? So go ahead and do some research in that, and we'll get back to that on the State Crime Lab and how that audit went in 2006 while they were testing Steve Avery's evidence. We'll come back to that at another video. And we continue. Clearly, the testing proposed by Dr. Selden would have met the requirements for State versus Plude 2008. Plude held when moving for a new trial based on the allegation of newly discovered evidence, a defendant must prove 1. The evidence was discovered after conviction. 2. The defendant was not negligent in seeking the evidence. And 3. The evidence is material to an issue in the case. And 4. The evidence is not merely cumulative. And then we go on to talk about Plude 2008. The state has state has deprived Mr. Avery of the opportunity to meet the Plude requirements and obtain new evidence or new trial. So how have they deprived him? They have violated the 974.06, the destruction of the biological evidence, by giving the bones away. And if you look at this motion above that we just read, that we have to Number one, the evidence was discovered after conviction. Well, the new DNA testing is, so we could do that. Number two, the defendant was not negligent in seeking the evidence. Well, he couldn't be because it wasn't available. Number three, the evidence is material to an issue in the case. Yes, the pelvic bones is evident. It is, in my opinion, evident to the case. And four, the evidence is not merely cumulative. But we have no bones, so we can't do it. So that's what she's talking about being deprived. The state has deprived Mr. Avery. Okay, the state by its actions has admitted that the bones are not only human, but also that they belong to Miss Halbach. The state, without notifying Mr. Avery and his attorneys, and during the pendency of Mr. Avery's direct appeal, caused material and apparently and potentially exculpatory evidence to be transmitted to the Halbach family for its destruction by cremation or burial. According to federal and state due process jurisprudence regarding the state's duty to preserve evidence, the appropriate remedy for a violation of Wisconsin's DNA evidence preservation statutes and the additional violation of April 4, 2007 trial court order in and of itself should result in the reversal of Mr. Avery's conviction. Amen and pass the butter. The violation of both orders is indisputably a due process violation that mandates Mr. Avery be granted a new trial. Okay, let's take a drink. We've got to say someone's name I don't like to say very often. All right. Kratz knowingly Kratz knowingly false representations during closing argument. The trial statements of Prosecutor Kratz indicate that he understood the exculpatory value of the gravel pit bones because he did everything to mislead and misrepresent to the jury that these bones were human. Prosecutor Kratz violated Mr. Avery's right to due process, where he concealed information and misrepresented to the jury during closing argument that the only human bone fragments were discovered in Mr. Avery's burn pit. So the state believes, this is him, you guys. Now remember this. So the state believes and the state argues that there isn't any question that it is, in fact, Teresa Halbach and her bones and her remains and her teeth that are recovered just a few feet behind Mr. Avery's garage and trailer. Stop there for a minute. You guys, the pelvic bones were absolutely found down in the quarry. And unless that quarry is a couple feet from his garage, then Kratz is full of baloney. And we continue. But I guess most importantly, when the bones of the victim are found 20 feet or so behind the property belonging to Mr. Avery, you stop looking. You stop looking for people like boyfriends or other customers or this kind of search. Okay, I got to stop right there a minute. Were they ever looking at these suspects? Because I'm just going to let you guys know something. When Ryan Hilligus is on the stand, he makes it clear that he was never treated as a suspect. Not once. Very clear. In order to not treat the ex boyfriend as a suspect, you risk, as a prosecutor of the defense, stringing along in front of that jury every single suspect to cause reasonable doubt to free your suspect, your client. So when they don't question Ryan, it leaves a big hard swallow there because it almost hints to premeditatedly knowing that the Denny law was going to exclude any suspects. And if that is the case, my friends, I'm going to tell you now the investigators at the high up levels that were investigating this case are implying in almost an embedded confession, in my opinion, that they knew they had the ace in the hole, the Denny law, and did not need to investigate any suspects from the get go. So, how would they know if that is the case? If it is, how would they know that they had the Denny law when they don't even know where she was last seen? They don't even know at that point, at the beginning of the investigation, where she was seen last. Where was her last appointment? But they've already targeted one individual. Okay, off the soapbox and continuing. Thank you for letting me kind of get some things off my chest. Prosecutor Kratz attempted to refute that the bones had been planted in Mr. Avery's burn pit by telling the jury the following. Bones were moved in this case. There's no question of that. No question of that. Who moved the bones to the state? Or, for the theory of the prosecution, is easy. Mr. Avery moved the bones. He moved the big bones. He moved the big bones, the ones he could identify as human bones, from his burn pit over to his sister's burn barrel. All right? That's a couple 100 feet away. If you think about the selfishness involved in that particular act, that I think is one factor. But I guess more importantly is directing attention away from himself. Might be the first night, maybe be the 31st, might be the first or the second, but he has got a couple of days, as it turns out, before the police officers actually start the investigation. Let's stop there for a minute. I don't know about you guys, but if somebody's wanting to get rid of evidence off their property, I dang sure think that they're going to get rid of it all to the best of their knowledge. And they're sure not going to, you know, just leave pieces of it. Now, when you look at where these bones were burned, if those bones if those bones can be tested, we'll know that. We'll know where they really originated, where which bones show where they were originally burned. If those bones, if we have them, the pelvic bones, we can test them and they're Teresa Hallbach's found down in that quarry, it's very possible we can also tell where the original burn site was. And if that original burn site was down in that quarry, he's a free man, and so is Brendan. There's no way other than that, because there's no way anybody with a logical brain, no matter how low your intelligence is going to purposely kill somebody off their property to avoid getting caught and then turn around and get a basket, get a barrel, and bring all that evidence home and put it in your own backyard. Won't happen. So here we go. Prosecutor Kratz deliberately misled the jury about the bones in the gravel pit when he made the following statement. The bones in the quarry I'm going to take about 20 seconds to talk about, because the best anybody can say is that they are possible human. What does possible human mean? Well, it means we don't know what it is. All right. The best anthropologists in the world don't know what these bones are. Dr. Eisenberg didn't know what these were. Dr. Fairgrieve didn't know what they were. He agreed with that, and you heard a stipulation being read to you by a person by the name of Les McCurdy. Stipulation just means an agreement between the parties of those bones. We felt it important enough. We sent out to the FBI, and Les Curdy from the FBI determined that the bones were so degraded that they were in such a shape that even through testing, what's called mitochondrial DNA testing, whether they are human or not, could not, even by the FBI, be determined. So the bones in the quarry are really not evidence in this case. And so Mr. Strang has made a big deal out of showing you maps and a little flag and things that about these possible bones. Again, speculation, conjecture, and is not part of this case. Facts are going to be what decides this case. Emphasis added. Prosecutor Kratz was well aware of the contents of these discovery disclosures prior to making his closing argument. He knew that 4 piles of human bones had been discovered in the gravel pit, and he actively misled the jury into believing that none of the bones were human. The Calumet County ledger sheets, Dr. Eisenberg's report, and the gravel pit bone pile maps clearly document that there were numerous bone fragments in the gravel pit that were human. The proper role of the criminal prosecutor is not simply to obtain a conviction, but to obtain a fair conviction. Thus, a prosecutor may not knowingly argue false evidence to the jury. A prosecutor knowingly false statements during closing argument violate a criminal defendant's right to due process. In Miller, the defendant was charged with sexually assaulting and murdering the victim. A pair of men's underwear shorts with dark reddish brown stains was recovered 3 days after the murder, approximately a mile from the crime scene. At the time of the trial, the prosecutor knew that the shorts had paint on them and even possessed a police report stating that the stains consisted of paint. I think that meant paint. Nevertheless, the prosecutor consistently and repeatedly misrepresented to the jury that the paint stains were actually the victim's blood. The United States Supreme Court concluded that the prosecutor deliberately misrepresented the truth, and in doing so violated the 14th Amendment. In United States versus Tony, 3 masked men robbed a bank in Ohio. Shortly after robbing, money taken from the bank was found during a search at Tony's residence. Tony claimed that he was only going Let me reread that. Tony claimed that he was going to participate in the robbery with Willie and Henry, but got nervous and backed out of the plan. A third man, Jimmy King, took his place. Tony maintained that he won the stolen bills the next day when gambling with a group of friends, which included King. King was arrested and gave a statement in which he admitted to gambling with Tony on the date of the robbery. At Tony's trial, King invoked his Fifth Amendment privilege against self incrimination. The trial court then held King's post arrest statement was inadmissible. During closing argument, the prosecutor argued as follows: I would ask you also to concentrate on this one fact. Have you heard any testimony from any witness, either the government brought forward or the defense brought forward, that Jimmy King did any gambling that night? Jimmy King was there, but Jimmy King, no witness has testified to you or told you did any gambling on the night of the 13th to 14th. And there is no testimony he was gambling or anywhere near a gambling place on the 13th or 14th in the afternoon. I submit to you, cut through the smoke screen. It is the defendant's contention he got the money from Jimmy King. The prosecution went on to argue that Tony's defense should be rejected because he had not produced any evidence to support his claim that he had been gambling with King after the robbery. The Sixth Circuit reversed Tony's conviction. The court noted that the prosecutor argued that there was no evidence to support Tony's claim, knowing full well the evidence did corroborate his claim. King's statement. The court held the prosecutor's knowingly false argument to be foul play and reversed Tony's conviction. Several other cases likewise hold where a prosecutor makes closing argument he knows to be untrue, even if not necessarily contradicted by the evidence or testimony admitted at trial. The defendant's right to due process is violated. Prosecutors' argument that motive for murder was robbery, despite knowing that the victim's property had been recovered by hospital personnel, violated due process. Prosecutors argue that there was no evidence supporting the defendant's alibi, despite knowing that there was a witness who offered some corroboration for it, not offered at trial, constituted reversible error. Prosecutors argue that defendant was untruthful when he testified he denied the crime to the police, despite possessing police reports wherein the defendant denied the crime. It was also foul blow that required reversal. Prosecutor Kratz clearly concealed that there was numerous gravel pit fragments that were human and dismissed the whew, suspected human pelvic bone position of trial defense counsel as speculative. Because of Prosecutor Kratz's misrepresentations to the jury, Mr. Avery's conviction must be reversed. We're going to take just 2 seconds because we're about to start the disqualification of Judge Sakawatsi. I can't wait. Little happy dance to see if this is going to work, but it should because she has done nothing but hinder this case with no reason to deny everything. So we're going to dig into that. I'm going to give you guys just a few minutes, check on you, see if anybody's still with me on this. I know it's just absolutely forever taking, but this is absolutely one of the most important documents we're going to see in this case, and we're going to stick it through for those that want to stay with me here. So, with that, I'm going to take a little mute here. I'm going to grab a drink and we'll get back on it. Let's take a 2 minute kind of catch our breath. All right, guys, and with that, we are back. Let's go ahead and check what page we're on. 38 of 41. If you are reading along with us, you can go to Rubber Ducky Stephen Avery Files.com. And you'll see a little picture there in a frame of our tutorial of how to work the library. It does contain a lot of documents. It's in the baby stages right now, but it still has an immense amount of information as well as a lot of interactive content. We're going to be starting a forum on there. We have added recently a maps page for all of you map buffs that are trying to track barrels and evidence, as well as one of the things we are doing is adding a multimedia room where you can go there and you can interact, whether you're a Twitter person or you're an Instagram person, Facebook, you name it, we've got it on there. As well as we're going to be including Millbilly's page soon in the next few weeks here so that you can watch his videos as well. He's very direct, to the point, and I love his videos. So here we go, you guys. I want to say real quick thank you to all the researchers, the RD researchers, and all the researchers on this case, and all the YouTubers that are working on this, as well as all of you followers and supporters of the Brendan Dassey and Stephen Avery case. You all are amazing. We are worldwide, and we all are on the same page, obviously. And we have a leader, which is Miss Zellner, and she's doing a heck of a job here. So let's dig into the fun part, you guys. It is the disqualification of Judge Suckowatz. So here we go. Although not strictly required by the Wisconsin Code of Judicial Conduct, Judge Suckowitz should disqualify herself from presiding over any further proceedings in this matter. By virtue of having presided over the prior civil suit filed case against Mr. Avery by the Halbach family for the death of Teresa Halbach, Judge Suckowitz should recuse herself from the pending post conviction case and it should be reassigned to a different judge. Judge Willis recused himself from the Halbach civil suit because he had presided over the criminal case, including the direct appeal and post conviction 809.30. Our legal system is based on the principle that an independent, fair, and competent judiciary will interpret and apply the laws that govern us. Code of Judicial Conduct, SCR 60 Preamble. And I quote, a judge shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. A judge is required to recuse himself or herself in a proceeding when, quote, well informed persons knowledgeable about judicial ethics standards and the justice system and aware of the facts and circumstances the judge knows or reasonably should know would rather would reasonably question the judge's ability to be impartial. End quote. Another quote. Under this rule, a judge must recuse himself or herself whenever the facts and circumstances the judge knows or reasonably should know raise reasonable question of the judge's ability to act impartially, regardless of whether any of the specific rules in SCR 60.04 applies. Let's stop there for a minute. Don't we have conflict of interest going on consistently throughout this case? Now let me just dive into conflict real quick. We're almost done here. So I'm gonna jump on my little soapbox one more time. I mean, I am a duck, I rubber duck, bath time, soapbox, you get it. Here's the thing. Conflict of interest. If you work for a hospital and you are a surgeon and that hospital is being sued by patient A, and that patient A grabs his heart right in front of you and he needs open heart surgery, you now have a conflict of interest, even if you just got hired by that hospital, had nothing to do with that prior case, because your boss is being sued by this patient previously. So if that patient that just grabbed their chest in front of you needs open heart surgery, your best bet is to recuse yourself and get another surgeon from a different hospital to perform surgery on him, because you naturally, even if your intent is all good, you would save his life in a heartbeat, apply yourself 100%. You naturally get a motive to perform so that it's to the best of your ability, perhaps, but in your favor. See? So it prevents you from acting honestly because people are going to have suspicion all around you. And that's what we have with Judge Sakawatsi. So we've got it back over here where if you scroll back up, we have that the previous judge had handled the civil suit where Tim Halbach sued a civil suit against Stephen Avery for all the money that he did get, which was 400,000. Now, the way we got out of that is he signed it all over to his lawyer, Buting, I believe. And he didn't have any money. He signed it all over. And there was no money to be had, so the Halbachs dropped the case. However, that's when the judge recused himself from that because Judge Willis was going to be handling the actual criminal trial. And he didn't want to have his hands in two cookie pots. See, if you've got your hand pulling out cookies over here and cookies over here, you're in conflict of interest. And so Mrs. Zellner is stating that so does Judge Sakawatsi. Judge Angie has no business in this case, is what she's saying, because she was involved in the civil suit. So, what's good for the goose is good for the gander. And we continue. Let's see, we left off right here. On March 24th, 2006, a wrongful death lawsuit was filed against Mr. Avery on behalf of Mrs. Halbach's estate. Halbach versus Avery, Manitowoc County case on or about October 29, 2013. Judge Suckowitz was assigned to preside over the lawsuit. On November 21st, 2013, plaintiff's counsel, this would be Tim Halbach, counsel filed a motion to voluntarily dismiss the case. On November 25th, 2013, Judge Sakawatsi, whatever her name is, held the plaintiff's motion in abey pending the resolution of Mr. Avery's criminal proceedings. So she already was in both cases at that point. I stepped off the page here for a minute. I've stepped away just so you know. This is right here where she's got her hand in both cookie jars. And it's being shown by Miss Zelder very clearly. And we continue. It was not until June 8, 2015, after Mr. Avery sent correspondence concerning the voluntary dismiss, that Judge Sakawatsi granted the plaintiff's motion to voluntarily dismiss the lawsuit. Having presided over the lawsuit filed by the Halbach family against Mr. Avery, Judge Suckowitz's ability to be impartial in the ongoing criminal proceedings against Mr. Avery is reasonably subject to question. Indeed, under the American Bar Association Code of Judicial Conduct, a judge must disqualify herself, himself, if he previously presided over the matter in another court. Wow, you guys, this is so wonderful. Whew, parentheses, judge required to recuse herself from trial for domestic battery after presiding over dependency neglect hearing related to the same accusations. And Wisconsin tribunes in similar situations have determined that their disqualification from criminal proceeding after having presided over a civil lawsuit involving the same subject matter is appropriate. Because Judge Sakawatsi presided over the civil lawsuit in which Mr. Avery was accused of causing Mrs. Halbach's death, she should disqualify herself from further participation in the criminal proceedings involving Mr. Avery. In a similar vein, Judge Sakawatsi's prior affiliation with Prosecutor Kratz likewise calls ooh, her impartiality into question. Judge Sakowitz and Prosecutor Kratz served together on the five-member Crime Victims' Rights Board in 2007 and 2008, the exact time frame during which Mr. Avery's criminal case went to trial and he was convicted. Again, Judge Sakawatsi's association with Prosecutor Kratz, advocating on behalf of crime victims at the same time Mr. Avery's criminal case went to trial, raises reasonable questions about her impartiality. A judge shall recuse herself if a lawyer with whom the judge previously practiced law served during such association as a lawyer concerning the matter. And we have it, everyone. Conclusion. Take a deep breath. We're on the last stroke to get home here. For all of the above stated reasons, Mr. Avery is requesting that his conviction be reversed and that his cause be set for a new trial and for any other relief that this court deems appropriate to grant. Dated this 11th day March 2019. Kathleen T. Zellner and Stephen G. Richards. That is awesome. Certification of service attached. And yes, you can see Lynn Zygmunt and Angela Sakawatsi, however you want to say it, Sekiewicz. I can't even say her name. I don't owe her any respect. I'm not gonna pronounce it right. Mark Williams and Thomas Fallon all have received copies, as well as our district attorney's office in Manitowoc. Everybody do the happy dance. I'm just saying, you guys. This is everything we've been waiting for. For those of you that are new to this case, for those of you that have been in it from the beginning, this is what we're nailing. We have got our toe in the door to this court. We're going to get this hearing on. Now we await what the state's response is. I believe there was a totality of 45 days, but in writing within 30. Correct me if I'm wrong. I'm absolutely not affiliated with a lawyer, nor am I a lawyer. I simply present this case at my humble understanding as a housewife and an armchair sleuth. So, with that, I'm going to join chat for just a minute because I missed everybody. And how we doing out here, everybody? How did that go for you guys? Longest I've ever read in my life. Whew. Now, if you want to throw a couple questions on the board, I'll do my very best to answer them. The best advice I have to give to you is if you do have any other further actual legal questions, Travis on the Eric Cozy channel, he's excellent at that. And Eric Cozy does allow those questions to get asked, and he does his best to answer. But if you do, I see a lot of beautiful, beautiful dancing, a lot of smiles, a lot of clapping. If you guys do have some case related questions, oh, thank you, Misunderstood. Great job, RD. Thank you. I appreciate it. I did my best. You can ask anybody. I had not read this beforehand, so I am on cloud nine right now. Obviously, I had not read it beforehand because I stumbled over an immense amount of words, made me sound a little dumb. But you know what? It's all about us getting the job done and getting those documents to Zellner if you think she doesn't have it. We do have a lot of documents in the RD library, which we are growing, and we are getting a lot of wonderful tips coming through our anonymous tips line. Let's see. Let's go ahead. If you say my name and I see it in red, I'm going to try to read your question if possible. So I see Charla Kane here, and she states, how long do they have to reply? Well, I know that within, like I said, I really think with that we used our time frame up, which was the 14 or 15 days Zellner had. I believe they have approximately the same timeline to respond to this. So I'm going to go ahead and just say logically, in my humble opinion, what I'm understood is that I would say they have 30 days to verbally respond. And I believe there was a 10 or 12-day grace period for the written response. The fact that we're seeing where she's asking Judge um, Sukowitz, or however you say her name, well, I'm just going to call her Judge Angie, to recuse herself, and she's provided great evidence as to why. Absolutely brilliant. Brilliant. The fact that she has called out Kratz in his opening and closing statements to nefariously mislead that jury with false information is insanely, it's just brilliant. It's just brilliant that she's calling this all out. So, okay, let's see here. Thanks so much, RD. Thank you. Thank you, guys. I see you all. Go ahead. If you want to join us, I'm going to throw up the Discord. I'll type that up for you. We're going to be transferring this live chat to a group chat. You're all welcome to join us on this channel. Once you click that, if you do not have Discord, you will get a short download, which is very quick, and immediately your feet land in the Puddle chat room, and you'll be able to type hi. So there's no buttons to click other than the download. Also, use the library, share the library. It's huge public awareness. We do pay for the library, and so we want people to use the library. And we are up to over 2,000 people, well over 2,000, that have made use of the library, and we appreciate you guys sharing it and bringing public awareness. We want to bring Brendan Dassey and Steve Avery home. both guys are innocent, and let's get them home and get back onto. Let's all get onto a new case. Let's bring them home, set him free, get Steven, get him a new truck. Let's get Brendan some pizza, some video games. Let's take a deep breath and celebrate. That's where we're headed, and that's where Zellner's taking us. So. Thank you guys so much. I'll read if we, what do you think the chances Judge Suck will recuse herself or hold an evidentiary hearing? What are the chances? You know what? I'm not a better, so I'm not going to say much. But the law is laid out pretty close here because of the fact that we do have some law words, which is shall and must, and Zellner's nailing those words. We're going to see how the appellate court comes back. Um, I would say we have a chance of her having to pull out now. I don't know though. I wish I was a lawyer. I could give you a lot better answer. Let's see, what else do we have? Braun says, I can't believe she managed to not include the word sweaty in her description of Kratz. Do you think it was in her draft? Yeah, that's a great question. Gotta love that sweet tea. So thank you there on Martha. Martha Dickinson's. Crap Ghost says Rubber Ducky is an angel. Nah, nah, no. No, I'm no different than you are. I promise you that. We're all on the same page here. We're all armchair sleuths, and we all want the best for these people. We're all walking in the truth, and that goes around. There was a day where all of us truthers, we were attacked by the guilters, and we all separated and segregated and fought amongst ourselves, and we tore ourselves up. But nowadays, we're all on the same page and we all support each other. That's why you hear Eric Cozy talk about Rubber Ducky and Rubber Ducky talk about Eric Cozy, and I talk about Millbilly, and I talk about a lot of the other YouTubers out there, Perplex and all of them. They're bringing awareness to the case, and all of you guys that are supporters, you're doing an amazing job by keeping the public aware of the case. That's what was used to frame them in the first place, is all the corruption fed through the fake news and the media to all the people, so that when they did pick the jury, they were intimidated, they believed a certain way. And we know now that the FBI did not match the bones to be a match to Teresa. They simply said they could not exclude her. In other words, there are others that could not be excluded as well. And I want to throw this out there before we head over to live chat. I've heard a lot of the people that are not sure of Stephen's guilt or innocence state that they base everything on the fact that Stephen threw an animal, a family pet, a cat, into the fire. Now, I am not excusing any behavior to animal cruelty. I am an animal lover. I'm a fur baby lover. But I will tell you that he was not the one to throw the cat into the flames. Yes, he was a youth. He did some wrong things. He did douse the cat in some inflammatory, and he did encourage it. But the gentleman that actually threw it in the fire was a separate individual. So, what I say to you is he made some horrible, horrible choices in his past. But it did not make him a murderer, and we do not have a fair trial. And, if we were to base it all on the fact that this cat got harmed, we would need to bring up this other gentleman on Teresa Halbach's murder or a murder, because obviously he's the one that threw the cat into the fire. So you really need to pay attention. And that's why we brought out the Steve Avery Library to clear up some of the base facts out there that are being fed to us that are not real. They're not truth. They're basically a twisted version, just like Kratz has done in his opening and his closing statements. So I want to say thank you all so, so much from the bottom of my heart for sticking with me on this extremely, extremely long video. Please do click the like button. It warms our heart. We did have about 114 people watching this today, which is a great response to a live chat without any prior knowledge that is going on. And I know a lot of people are working. So thank you from the bottom of my heart. And it's time to say, come on over on the Discord if you want to do group chat. Visit that library. Please tweet the words Wake Up Wisconsin, Nudge the Judge, hashtag Work with Zellner, and hashtag Ducks in a Row. So with that, it's time to say it. Are you ready? If say it with me, you guys. If you didn't do the crime, you shouldn't sit the time, or you shouldn't do the time. Thank you guys and have a great day.